The executive power of the presidency has a number of different aspects that would be important for us to look at here. First of all, the president has the power to execute the law. That is his primary focus according to Article number 2 of the Constitution. President Jefferson believed the execution of laws more important than the making of them. Whether you agree with that or not, we do know that the president can execute the laws in any way that he deems fit. He has discretion to determine how he's going to enforce and how he's going to interpret the laws in the way that those should be carried out. And so there are a number of powers in here that would be important for us to note. The first one here is the ordinance power. More often we tend to see this as the executive order power. The presidents here have the ability to issue decrees that have the force of law. And so for every practical implication, these work as laws. But they differ from laws in the fact that they are issued by a single person and they don't have to have congressional approval. He can sign this into as an executive order, and it carries the weight of it as if it were a law signed by Congress. They're all published in the Federal Register as they are made, so that way they are public knowledge, and they are published every year in the Code of Federal Regulations, just so that way everybody can be aware of where they are and what's going on. So presidents can issue these executive orders for a number of different reasons. Sometimes the president will issue them for ceremonial or symbolic purposes. As an executive order, he has the ability to do that. Secondly, presidents can issue them for national security or to do something in order to defend our country very quickly. In a time where he would not have time to go through Congress, he could issue something like this. President Trump used this when he was concerned about certain groups of people that were coming into the United States from Middle Eastern countries that had ties to the Taliban. And so he issued an executive order that would limit or ban certain people from coming into the United States or traveling into the United States without proper documentation. Some people thought that that was a violation of his power, and some of the courts struck that down and refused that executive order. And we'll talk about that a little bit later. And then, thirdly, the president may use this or these lost my place in my notes. Here it is. The executive orders can set public policy without the use of Congress. And so presidents can kind of bypass while they're trying to make this happen. Now, there's a strategy involved in that. Some people would, for fear of the retaliation of that, but they do have the ability to go ahead and set public policy. The Emancipation Proclamation was an idea that would have followed along with this. Many presidents have used executive order to help set their policy, but have not wanted to pursue something in Congress this way. President Trump has threatened to use this and I guess he has used it. President Obama used it recently as well. And so executive orders there. Now, presidents cannot directly contradict Congress or the Constitution through an executive order. So he can't bypass a law by creating a new executive order. That is prohibited. There are three ways that executive orders can be changed. First of all, courts can overturn executive orders, and this can be done by individual state courts, or it can be done by the Supreme Court. And if a state court refuses to acknowledge it, then it does not have to be enforced in that particular state. If the Supreme Court casts it down, then of course no state's going to have to worry about it. Secondly, Congress can overturn the executive order through legislation. If they don't like the way the president executed this or put this into practice, then they have the ability to create a law which would then cancel out the executive order. The third way is for a succeeding president to veto or to reverse that executive order. And presidents will often do that as they want to change policy. They'll come in and they'll change that up. President also has appointment power, the ability to appoint new high-ranking officers to the federal government. perhaps the most well-known is cabinet secretaries, as presidents get to pick their own leaders of those various departments. They get to pick them, and then they have to be approved through the Senate. Same thing happens with the judicial branch, the Supreme Court justices, federal courts. All of those get to be picked by the president, but it goes back to the Senate, and the Senate has to approve in order to get those people through. A majority of the Senate has to vote to confirm the appointee before he is able to take office. There is a way for the president to get around Senate confirmation, but it's a temporary appointment. This is called a recess appointment. I'll go ahead and mark that in your notes. It's called a recess appointment. So if the Senate is out of Congress, they are not meeting, they're in recess, the president could make an appointment, and that appointment would be valid until the next session of Congress is over. So it would be very temporary, but the president does have the ability to do so. Senators get very upset if the president tries to do this. And so most presidents will not, because they know that if they try to do this, it's going to be something very short-lived, and when it comes time for the confirmation hearings, the Senate's going to be so upset and angry with the president that he did this that they're not going to vote this guy through. But it's there in case of an emergency type of situation where Congress cannot meet and the president needs somebody in there. He could do it immediately without their consent. The president also has removal power. Throughout history, a number of people have argued that the president should not be able to dismiss anybody that has been approved by the Senate without first receiving Senate approval. So this perhaps happened most famously with Andrew Johnson, where he had inherited President Lincoln's cabinet, and he wanted to get rid of a number of people out of that cabinet. Congress passed a Tenure of Office Act in 1867, and it required the president to get Senate approval of a replacement before firing anybody out of that office. So when Congress presented that bill to President Johnson did not like it. He vetoed the bill and sent it back and said, "I do not approve of this. We should not make this a law." Congress was so upset about him vetoing this and so nervous about Johnson as president that they overrode his veto with a 2/3 majority vote. And they have the power to do that, and that means that the bill becomes a law even though the president never signed it. So it goes into effect, and President Johnson went ahead and he fired his Secretary of War, Edwin Stanton, just in defiance of that law because he didn't believe it was constitutional and he did not agree with it. Well, that gave Congress the grounds to go through the process of impeachment because he had now violated a law. And so go through the impeachment process. I'm going to have you click on a link for a video here in a moment that will give you the opportunity to take a look at his presidency as well as his impeachment. And he falls one vote shy of impeachment, and so he continues on as president. This law is later deemed unconstitutional, so President Johnson was right, but didn't save him the heartache of having to go through all this trouble. The general rule today is that presidents should not fire anybody that he appoints except, the general rule is that the president may fire anybody that he wants except for federal judges. So anybody out of his cabinet, he is pretty free to exchange out, and the Senate is usually okay with that. When we look at federal judges, that is the exception where the Senate would not be as excited about that. Now, it's important that we also move on and talk about executive privilege. Most presidents over the last 50 or 60 years have argued that they have executive privilege. This idea is that they may constitutionally refuse to disclose information to Congress or the judicial branch. So they have an executive bubble in which they can keep information private and do not have to give away that information to one of the other two branches. So this is an executive privilege. It's kind of like your attorney-client or a doctor's confidentiality. The refusal to disclose any pertinent information generally goes to any form of records that the president has as private or conversations with his close advisors. And so, of course, President Nixon would be the best example of this, in which he claimed executive privilege when Congress wanted to hear the tapes that he had used in his office. He had secretly recorded every conversation, including conversations where he was recording himself. I'm not sure exactly why. He forgot that the tapes were rolling. I'm not sure what was going on. But he recorded himself authorizing the break-in of the Democratic Party headquarters, and those tapes were incriminating for him, violating law, and therefore would lead to his impeachment. He claimed executive order or executive privilege, that he didn't have to turn those tapes over because that was a private conversation in his office. However, Congress and the court agreed that executive privilege did not extend to matters of criminal activity. And if it meant that it revealed that he was doing something illegal, which he was, then he had to turn over those tapes. Once he turned over those tapes, he realized impeachment was impending, and therefore he went ahead and resigned.